Tully Rinckey, PLLC, thanks the Blacks in Government Executive Committee for allowing the firm to present this free webinar to Blacks in Government members. The firm supports the goals and objectives of Blacks in Government, and we're pleased to be of service to you. Through our partnership, Blacks in Government members are entitled to 2 free half-hour phone consults per year regarding federal employment, security clearance, or military matters. Members pursuing claims receive a 10% discount on legal fees. Call us at 1-888-529-4543 or email info@fedattorney.com to learn more about our partnership with Blacks in Government and schedule your free consultation. Tully Rinckey, PLLC partner Rachel S. Young, Esquire, provides representation to federal employees in a wide range of employment and labor matters, including claims of age, gender, race, national origin and color discrimination, sexual harassment, wrongful discharge, and retaliation. Ms. Young has practiced frequently before federal, state, and District of Columbia courts, in addition to representing clients before the Equal Employment Opportunity Commission, the D.C. Office of Human Rights, and other state and local administrative bodies. Tully Rinckey, PLLC is one of the nation's largest federal sector labor and employment and military law firms. We're a full-service firm for federal and government employees with legal issues. Our attorneys together have about 130 years of experience practicing federal employment law. They're key components of a team whose targeted, aggressive legal approach has secured positive results for clients in virtually every aspect of federal employment and labor law. Don't leave the future of your federal career to chance. Call 1-888-529-4543 or email info@fedattorney.com to schedule your free consultation with a member of our team. Now, I'll turn the floor over to Rachel S. Young, Esquire.
To establish that you are someone with an actual disability, an employee or applicant needs to know that they need to establish that they are suffering from a physical or mental impairment that substantially limits you in one or more major life activities. There are many different types of life activities that can meet this definition, and we've included some of those activities on the screen, such as walking, sitting, sleeping, or learning are examples of major life activities. This is, of course, a non-exhaustive list, and there are other functions that are major bodily functions that might qualify to help you meet this definition as well, such as limitations on the respiratory system, the digestive system, the reproductive system. There are many different characteristics that may help someone satisfy the definition of a major life activity for determining that you have an actual disability. With respect to the second prong that I mentioned a few minutes ago, which was a record of disability, one might also meet the definition of showing that they are subject to protections under the Rehabilitation Act if they simply have a record of having a prior disability. And as I've noted here on the screen, a record of an impairment is someone that has a history of once having suffered from a physical or mental impairment that is substantially limiting in a major life activity. So even if you have recovered from some sort of condition and the employer is aware of that past history, you may still qualify for protection under the Act. And a great example of this might be someone who is suffering from cancer, whose cancer has now gone into remission. So if the agency is on notice of the fact that you had cancer and they perceive you as having a record of that particular medical condition, you might be able to satisfy this particular prong in showing that you were deemed disabled under the Rehabilitation Act. Moving on to the next slide, I mentioned perceived disability as well. And a perceived disability is slightly different. A perceived disability is someone who may or may not be disabled, but the employer believes that this person is suffering from a physical or medical or mental impairment that is substantially limiting. And in this situation, what we are looking at is the supervisor or the agency's belief as to what a particular employee is going through or perhaps may be going through. And under this particular provision, even if you are someone who is not suffering from such a condition, meaning you are not actually disabled and maybe you don't even have a record of a disability. If you are being perceived as disabled in the workplace, this might be a provision that would apply to you and give you protections under the law as well. So long as what they are perceiving in you is a condition that is not a transitory one, meaning something that might last 6 months or longer, such as a broken arm, or something that is minor in nature. As I talk about the description of these different prongs of, what can allow someone to qualify as being disabled, it's also important to note that, certainly from the perspective of asserting legal rights, it may be very helpful to employees to consult with an attorney to develop a legal strategy that pertains to which prong you are going to proceed under in asserting your claims. I, in the course of my practice, have conversations with employees all the time. Sometimes we have people that satisfy one or more of these different conditions, and what we are trying to do is to establish and evaluate the best particular course of action for you as we go about trying to vindicate and prosecute your legal rights. So I should note that, certainly in the course of proving disability discrimination or some other form outlawed by the Rehabilitation Act, it might be helpful to assess, what are the legal requirements that you need to show based on your particular goals, and to assess how to best accomplish your personal and specific goals of prosecuting that action. So now that we've sort of established the parameters of how to show that you are disabled, I want to turn our focus a little bit to the subject of reasonable accommodations, what they are, and how to qualify for them. The law requires that employers, including federal agencies, provide reasonable accommodations to people who are qualified individuals with disabilities. That includes employees as well as applicants. And the requirement that is imposed by the law applies to employers unless providing a reasonable accommodation institutes some sort of undue burden for the agency. And I'm going to break down in a number of different slides what exactly that means. First of all, it's important to note that a reasonable accommodation is any change in the workplace or the work environment or the way that things are typically or usually done that affords someone with a disability the ability to have a fair opportunity to strike back. So I'd like to turn our discussion to looking at what a reasonable accommodation is pursuant to the Rehabilitation Act, what it means to you in terms of the opportunities that are presented, and how to qualify and to secure those sorts of opportunities for someone who is disabled. So to begin, what is a reasonable accommodation? Well, under the law, an employer has to provide reasonable accommodations to a person who is a qualified individual with a disability. That includes employees as well as applicants, unless the provision of such accommodation constitutes an undue burden. So to break that down, a reasonable accommodation is essentially any change in the workplace or the work environment or the way that things are just normally done that allows someone with a physical or mental limitation to receive their treatment. Specifically, this can include things such as modifications or changes to the job application process that allows someone who is applying for a position to receive their consideration. An example of such an accommodation might be affording someone more time on a entrance examination or some sort of condition of employment test that allows someone to have the time that they need pursuant to their medical condition to complete and to have a fair opportunity to pass the test. That's a wonderful example. Another opportunity or example of a modification that would be constituted a reasonable accommodation might be adjusting someone's duties or assignments to allow them to perform the duties of their position or to receive fair benefits and privileges of employment in the workplace. It is important to note that that the grant of this right is not unlimited in nature. Under the statutory provisions, the agency is not required to provide reasonable accommodations to people unless they can demonstrate that it's necessary to ensure fair opportunities or access to the privileges and benefits of employment that others have, or to help them perform the essential functions of their position, or apply for and be considered for a position. In the process of making a request for reasonable accommodation, the agency is not mandated to give someone exactly what they want. But as I will detail during the course of this presentation, there's going to be an interactive process involved that is in fact mandated by law to ensure that the needs of a person can be reconciled with the things and the opportunities that lead to success. And I'll go into more detail on this on the next slide. Specifically, in looking at the question of whether or not someone is entitled to receive a reasonable accommodation, we are looking at, what the specific job function is. And ultimately, it's going to be a question of fact as to whether or not you are entitled to, based on your position, a reasonable accommodation. So it's analyzed on a case-by-case scenario. Every case is different. So when we are looking at making this assessment, it's important to note that whatever is included in your position description or every task that is assigned to you may not be deemed as being an essential function. So what we want to sit down and do in making this analysis is to look to your particular job function and to your particular needs, and to assess what might be an appropriate reasonable accommodation for you under the circumstances that leads to be able to do your job. So as I indicated, this is a very sort of detailed analysis that needs to be conducted. Moving along to our next slide, we have taken the opportunity to just identify a number of different opportunities or examples of reasonable accommodations that might be appropriate given someone's needs. As I mentioned before, this might include the modification of policies such as T&A or time and attendance policies. It might include the opportunity for telework or a modified working schedule. It might include the necessity of reassigning someone to a vacant position, and there's a lot of intricacies related to that approach. The provision of training, the provision of computer monitoring or other types of equipment, and other adjustments or modifications to the work environment. So now that we've talked a little bit about what a reasonable accommodation is, I want to talk about how to get one, how to go about the process of instituting this need. Most agencies have formal policies as to how employees are to go about requesting reasonable accommodation. Suffice it to say for our discussion that it is adequate here, irrespective of what that policy says, if you as an employee approach your manager or your leadership and say, look, I need help for my medical condition receiving some sort of accommodations to do my job. That statement alone is enough to institute the reasonable accommodation process. And once that process is instituted, as an employee, you do have an obligation to A, show that you are qualified, and then B, to cooperate with the agency during the course of the reasonable accommodation process to ensure that you obtain what you need to do your job. So as listed here on the screen, the employee has the burden of first establishing that they are a qualified individual with a disability. So in order to qualify for reasonable accommodations, you need to basically establish the actual prong of a disability that I referenced earlier. You need to show you have an actual disability. So that means you have to show that you are suffering from a physical or mental limitation that substantially limits you on one or more major life activity or bodily function, as we went over earlier. And we also need to show, to the extent that you're seeking a modification to your position, we need to show that the accommodation that is sought will not preclude you from performing the essential functions of your position with having that reasonable accommodation to ensure that you remain covered by the Act. Once you have made that showing, as I indicated, you do have a duty to reasonably cooperate with the agency in terms of following the procedures in place for obtaining reasonable accommodation. As I mentioned, you can institute your request verbally in writing. As a lawyer, I would encourage you to certainly do it in writing so that you can prove what you said and when you said it. But then also, once that process has been instituted, to the extent that the agency makes reasonable requests for documentation or for additional information or needs, more material that supports what you need, then you have a duty to reasonably comply with and help them process your request for accommodation. Now, certainly in the course of my practice, we have seen many situations where agencies may go overboard in their demands for documentation. So if you feel like you are in a position where you have sort of expanded from what should be ordinary and reasonable under the process into a situation where you feel like you are being harassed or subjected to undue demand in making your request for accommodations known, that again would be another great opportunity for you to consult with an attorney who can give you some advice on that gray area of whether or not A, you need to comply and it's in your best interest to do so, or B, whether the agency's actions are giving rise to a particular claim for harassment or for discrimination under the Act as well. So there can be a gray area, and to the extent that we can help you in evaluating what is happening in your particular situation, of course, a qualified attorney should be able to help you understand those parameters. Certainly, my general advice is that you want to try to cooperate with all reasonable requests for documentation. Another point that I'd like to point out to you here is it is critical to involve your doctor, your physicians, your psychiatrist, whomever is your treating healthcare provider. It's really, in my opinion, very helpful to involve the medical provider in the discussions as to what is necessary and what would be helpful in securing reasonable accommodation. So in the course of my practice, whenever someone wants accommodation, and it may be, somewhat of a complex nature, we try to incorporate the doctors in the process. And what we like to see the doctors do is to provide information to the agencies that explain the diagnosis, the prognosis, the course of treatment, and of course, the doctor's medical recommendations after having reviewed the physician description or whatever issue is in dispute that can give some guidance to the agency and to the employee and to the lawyer as to what might be the best course of action for this particular individual in helping them receive the protections that they need. So certainly, having the doctor involved is really an integral part of the process in ensuring that your request for accommodation is a successful one. In the course of making this request, the agency has the ability and the burden of evaluating whether the requested accommodation is reasonable under the law. And what can be done in this process is to look to what accommodations have been provided to people who are similarly situated, talking with both the employee and their leadership about what accommodation is appropriate, consulting with human resources, consulting with the legal department, consulting with the attorneys, and consulting with the EEO office or the specific disability coordinators to figure out what is reasonable. Engaging in this process is called an interactive process, where one or more different offices or entities all collaborate in an effort to try to ensure that the disabled individual receives what they need to do their job or to have their employment opportunities. So moving forward, as I sort of alluded to a few minutes ago, there are limitations on what the agency needs to do in the provision of reasonable accommodation. And as employees making these requests, we want to ensure that the requests that we are making, for employees fall within the legal parameters of what the agency should have an obligation to fulfill. So specifically, as I've mentioned, the agency does not have accommodation that the agency is providing does need to be an effective accommodation. So as our topic today is limited to in-office accommodation, so we're not talking about things that might be done outside of the office, telework, et cetera, what we're looking at there is a situation where we want to ensure that that process leads to a very precise identification of what the employee needs and the reasons that the employee needs such accommodation. That is very essential to going through this process. There are some limitations, as I mentioned here, in terms of what the agencies need to do. If the agency have presented some sort of direct threat or significant risk of harm to the health or safety of either that employee himself or herself or others in the work environment, and that direct threat cannot be reduced or otherwise precluded or eliminated through the provision of reasonable accommodation. Under such a circumstance, the agency is not required to provide a reasonable accommodation. Likewise, the agency is not required to provide accommodation where there constitutes an undue burden. Generally, an undue burden is defined in terms of what the financial cost or burden is to the agency. Luckily for us, the EEOC's laws are very favorable on the concept of what might constitute an undue burden. So, for instance, purchasing $100 worth of computer software, that's $100, but that is not an undue burden. Purchasing, certainly in the course of my representation of a lot of people with disabilities, we've been able to secure things such as ergonomic workstations and lots of different things, modifications to someone's workstation, lots of different things that can afford an employee the opportunity to have fair, equal opportunities and the ability to perform their job functions and duties. So the mere fact that it costs the agency some money is not necessarily determinative of whether this is an undue burden. Rather, if the financial cost becomes extensive or burdensome or reaches a certain threshold, at that point, then we must evaluate whether or not the agency has the requirement under the law to provide the accommodation that the employee needs to do their job. So as I've indicated here on the screen, the mere fact that, this costs money does not actually preclude the agency from having a definitive responsibility to provide the employee with what they need. The goal, again, is to ensure that what is provided is an effective means of helping the employee do their job. So to switch gears here a little bit, I want to move into what happens if you believe you are in a situation where you qualify for legal protection, you have an actual disability, you are seeking an in-office accommodation, and the agency denies your request. Unfortunately, this makes up a significant portion of my practice. People that we believe are disabled that meet the legal definition, and for a variety of reasons, the agency has failed or is failing to provide prompt and efficient and appropriate accommodations to that person. If you find yourself in that situation, it is important to note that there are very critical steps that you can take to protect your rights. That ordinarily begins with the administrative EEO process. And that would include reaching out to your local EEO office, asking to speak with an EEO counselor. And as a lawyer, I would advise you to make the contact if it needs to be done, verbally, to do so, verbally initially, but to also to document the fact that you've made such contact in writing so that we can prove that you have taken the first step in the process as an employee to ensuring your rights are protected. Once you contact the EEO counselor to initiate that process, you want to provide that individual with information that shows why you believe you are entitled to a reasonable accommodation, how you went through the reasonable accommodation process, if you have. Certainly if you're in a situation where you are asking for an accommodation and your request falls on deaf ears, meaning that the agency and your supervisors take no action to process your request, then the opportunity is ripe for you to meet with the EEO counselor, provide them with the background on what has happened, and to ensure that the process moves forward in, certainly trying to either engage in traditional counseling with the EEO counselor or to request for alternative dispute resolution through the form of mediation, to have a sit-down meeting with your leadership and to talk about what you asked for, what happened, and what you still need. And that's essentially what the early stages of the EEO process will entail. This process is one that begins there but has many different stages and steps in the process, and ultimately, if not corrected, can lead to litigation against your agency to ensure your rights are protected. At this stage in the process, I would encourage you, if you find that you are in a situation where you are either A, evaluating whether you are entitled to protection under the law, or whether you are in a situation where you have asked the agency for reasonable accommodations and either the agency has not responded or it has responded in a negative fashion by either not giving you the accommodations that you need to effectively perform and to have equal access to the privileges and benefits of employment, or has denied your request for reasons that you believe are unjustified, this might be the best time to contact an experienced attorney. There is a current, daily, day-to-day need that you have. And if that need is not quickly, promptly, and effectively met, you can end up in a situation where your career is being threatened, where your performance is being challenged, and other things that are not desirable are affecting you in the workplace. So for people that need reasonable accommodation, it is very critical that prompt steps are undertaken to ensure that you have the immediate availability to pursue your rights. In my opinion, certainly when you go down the EEO route of pursuing, that process, I often strongly encourage people to try the alternative dispute resolution process. For me and my clients, we have had a great deal of success in having everyone sit down at the table very early on in the process to address those needs. While certainly not every situation can be addressed at that stage, to the extent that we are successful in achieving early resolution, what we are doing is addressing an immediate problem and trying to prevent it from growing and sort of ballooning into something that is so great that it leads and exposes the employee to negative consequences. Finally, I'd like to touch upon the ways in which an experienced attorney can assist you in the process of protecting your rights. First of all, an attorney can assist you in both counseling you on how to recognize your claims and secondly, ensuring that you have taken the appropriate steps to preserve your ability to pursue those claims in the event that that is necessary. Secondly, an experienced lawyer can help you in negotiating with the agency to settle any disputes that might arise. As I've alluded to before, the alternative dispute resolution process is a wonderful opportunity, in my opinion, of helping people attain the accommodations that they need to do their job. So thirdly, turning our attention to the next slide, it's very important that an attorney help you ensure the timeliness of whatever you are complaining about during the process. While the failure to provide reasonable accommodations is a continuing infraction, meaning that it includes on a day-to-day basis until you receive an effective accommodation for what you need. To the extent that you are alleging some other type of a disability discrimination claim, such as disability discrimination and harassment by an employer or some level of retaliation, there may be very specific deadlines that apply to your ability to assert those claims. And an experienced lawyer who understands federal employment law can help you ensure that you do not miss those deadlines and that appropriate steps are taken to prove as a matter of law that you have complied with your obligations in that respect. Finally, an attorney can serve a very critical role in helping you level the playing field to prevent injustice. I cannot even begin to tell you the number of people I have consulted with over the course of my career who have tried to navigate the process alone. Sometimes they are successful, and sometimes their pleas fall on deaf ears. And what an attorney can do is ensure that the agencies take you seriously, show them that you are serious about protecting your rights, and help you leverage your rights to the degree and to the extent possible, whether it be through aggressive defense tactics or undertaking steps and strategies to help the agency understand what the stakes would be if this matter proceeds to the next step. So attorneys can play a very critical role in helping you leverage yourself as one employee against a powerful agency to ensure that they follow the law and that they they do what is necessary to ensure that their disabled employees as well as applicants receive fair opportunities under the law. So with that being said, I hope that you have enjoyed our presentation today. I'd like to thank Steve Bolano for introducing me today. And Steve, at this point, I will turn it back over to you. Thank you.
Thank you for participating in this webinar. If you'd like to learn more about how to best defend your federal career, call 1-888-529-4543 or email info@fedattorney.com to schedule your free consultation with a member of our team. As a reminder, our experienced team of national security clearance attorneys regularly assists federal employees and contractors, as well as military personnel in all stages of the security clearance process. They've helped hundreds retain their clearances. Our military law team is nationally recognized for its ability to win cases against tough odds. Our military lawyers have proven track records of changing the military law landscape through knowledge and tenacity in all matters faced by service members, including but not limited to courts-martial, discharge upgrades, and desertion. Don't leave the future of your federal career to chance. Call 1-888-529-4543 or email info@fedattorney.com to schedule your free consultation with a member of our team.